The truth is, you need an attorney to do probate in Florida. You might not like it, and you might try to find some way to get around it, and maybe some judges will allow you to get around it. But right now, as we sit in 2025, under the Florida probate rules, you are required to have an attorney. Let's look at the rule. So I have Westlaw pulled up here, which is just one of the many legal research platforms that attorneys use to find, current rules, current statutes, current cases. And under Rule 5.030, which governs attorneys in probate, so we're looking at Florida Probate Rule 5.030, I'm going to first read you the first sentence here. Every guardian and every personal representative, that'll be important later, unless the personal representative remains the sole interested person, that will also be important later, shall, which means must, be represented by an attorney admitted to practice in Florida. So first reading, let's just cut that short. So every personal representative must be represented by an attorney that's licensed in Florida. So if we look at this rule of probate, we first see that every personal representative, and the personal representative is the person appointed by the court to oversee and help administer the probate process. So what I'm reading, what I'm hearing and reading in this statute is every estate where there's a personal representative, and I have yet to see one where there is none, maybe that's the guardianship carve out. So every estate where there's a personal representative, that personal representative must, absolutely must, be represented by an attorney who is licensed in Florida, a Florida attorney. Now there is an exception. Unless the personal representative remains the sole interested person. Now, the sole interested person it's broad because an interested person in probate, and I'll pull up the rule if we need to, is actually quite broad. It doesn't necessarily just mean family members. It means any person having an interest in the estate. And so, to me, reading this, it appears that every estate in the state of Florida must have an attorney that's representing the estate. Now, I have yet to see in my practice where the probate court allowed an estate to be administered without a probate attorney. Now, I'm wondering if there's carve outs for small estates, for summary administration, where someone may be able to do it on their own. Now, there is a carve out here that if the personal representative is the attorney, they can do it themselves. But when we read this rule, what it appears to me as an attorney is that every estate must have an attorney. And I remember early in my career, I actually had someone call me and he tried to do it himself, but the probate court told him, and this was in Martin County, Florida, told him that he was unable to proceed. That even if all of his filings were appropriately done correctly, he cannot administer the estate on his own without an attorney. And and I know this is just great for attorneys, but the idea is, and remember, when someone's passed away, that person can no longer speak for themselves. We require some judicial oversight to ensure that their wishes or the law is being properly followed because they cannot speak for themselves any longer. So I imagine, without reading the legislative history, which is why these rules came into effect, or or reading the committee notes for the revisions on these rules for why they were added, I imagine it's to protect those who don't have a voice. So this is great for attorneys in the state of Florida. Not great for everybody else because I don't know personally any attorneys that do probate work on a pro bono or low bono, which means free or reduced rate basis. Most do it on a contingency fee or on an hourly rate, and that's how our firm does it. I just find that interesting. I would love to hear what everyone's thoughts are because this is a rule in Florida as of right now. It came into effect in 2021 and is still good law or a valid rule here in 2025. Well, what do you think? Do you think that attorneys should be required to represent estates? Do you think it's necessary to have an attorney? who does it hurt? Who does it help? To me, or first blush, this helps attorneys. This is ensuring right now that I will have a job doing estate work because for probate it's required to have an attorney. So even though we're all with the buzz with the AI and Elon's robots and the Chinese robots and everything like that, at least right now you're required to have an attorney that's licensed in Florida. So right now I'm protected. We're going to have a job as probate attorneys, at least for the foreseeable future until this probate rules change. So it is true in 2025 that most, and I'm sure 99% of estates, are required to have an attorney to help them. So let me know in the comments what you guys think. We'll see you on the next one.